Hi everybody. So let me introduce myself. My name is Mojgan Khoshbakht and I am an immigration attorney practicing in Los Angeles in California. And today it's a pleasure to have this presentation with you guys on behalf of Iranian American Bar Association. And it's a pleasure to be the guest of IABA San Diego chapter. So we're waiting for more friends to join to start the presentation. Hope everyone's staying safe and staying well during this COVID-19 crisis. I know that many of the businesses are slowly starting again their businesses and going back to their offices. Hope everyone are following all the precautions necessary to keep their employees and also their clients safe by following all the protocols to prevent the spread of this virus. Okay, so I have always been grateful to Iranian American Bar Association and especially the San Diego chapter because I always feel, even though I moved to Los Angeles 2 years ago, I was living in San Diego, but I moved here, but I always feel I'm still a member in the family of Iranian American Bar Association, the San Diego chapter, because they are very friendly and nice attorneys who mentor each other and help each other, and I always appreciate their help in during my career, and I'm always grateful to them. And today it's a pleasure to be the speaker for IABA. I wish we could have this in person and meet all of you guys there and have an in-person presentation with IABA, but this is what it is now, and we have to actually do this to keep ourselves and also you guys safe. So today I'm gonna talk about the new public charge rule and also the effects of COVID-19 on immigration law and how it actually changed the immigration law during the past month, during this short period of time. I think most of you have heard of public charge rule and what it is, but today I'm going to give you more detail about what the definition of public charge is and how it's actually going to affect on it will have an effect on people or immigrants who want to file their immigration applications or petitions to USCIS or either through consular processing. So because these are two different subjects, what I'm going to do, I'm going to first start talking about the new public charge rule, and then I will discuss about the effects of COVID-19 on immigration. And during my speech and presentation, if you have any questions that's related to this topic, you can definitely write your questions on the comments, and at the end of the presentation, I will try to answer all your questions. Okay, so about the public charge rule, this concept of public charge has always been in the immigration rules of the United States, and it has been there since 1800. And it has always been to say that someone is a public charge if the government would find that this person is likely to become a burden on the government after becoming a lawful permanent resident, which means a green card holder. So this has always been there, but in actually 2018, the department, the DHS, Department of Homeland Security, actually issued a new public charge rule, which is called Final Public Charge Rule, that they changed the definition of a person who is going to be found public charge, and also they added new standard of how to find a person will be a public charge or not. So that's actually the new changes that happened to this old and in existence rule of public charge. This new public charge rule has been into effect from February 24, 2020, and all applications or petitions that are filed or postmarked on or after February 24, 2020 will be subject to the new public charge rule. So that's actually the effective date of the new public charge rule. So as I told you, they changed the definition of public charge rule. So based on the new public charge rule, a person who is likely to become a public charge and who actually used or received one or more of the specified public benefits that are actually specified in the public charge rule during 12 months in the aggregate within any 36-month period will become a public charge if they filed their applications or petitions that are filed or postmarked on or after February 24, 2020. So I will tell you what are those benefits, and also what specific benefits are not actually included in the new public charge rule. So that's actually the new definition of public charge rule, and like who will become a public charge, and that was the definition of it. And another thing that they added to the new public charge rule is the new standard of review, or a new test that they are going to look at when they are adjudicating an application or petition to see if the person will become or is a public charge. And this test or standard of review is the totality of the circumstances. So what this means is that they, with this new public charge rule, DHS actually added new factors that they would consider either negative factors or positive factors, that they are looking at these factors, which I tell you later, and they will decide by totality of circumstances, like looking at all these negative or positive factors, to find if the person would become a public charge in the future. So what are these new factors that the government will look at, either USCIS officer or a consular, an officer, and at the consular processing stage. So the first factor is the income and assets. So what does that mean? So based on the new public charge rule, and under the new public charge rule, they are looking at the income and assets of the applicant, like the person who is actually filing their application or petition for receiving their green card, either in the United States or outside the United States through consular processing. So then they actually made positive factors or negative factors as to the income and asset requirements. So, for example, if a person's the applicant, I'm talking, when I say person, I'm talking about the applicant who is actually applying for their green card application. So, if applicant's income is actually below 125% of the federal poverty guideline, for a family of 4, for example, if it's below 32,750 a year, unless the household has other specific income, then that would be a negative factor in his or her application. And another negative factor is if, for example, before February 24, 2020, the person or the applicant actually applied for fee waivers for his or her immigration application, that would also be a negative factor. So let me explain about the fee waiver. So for some of the applications or petitions that you file to USCIS, there are specific fees that you have to pay to the government to adjudicate these applications or petitions. So for some of these applications and petitions, you might be able to request for a fee waiver based on your income, showing that you do not have a sufficient income, so the government would waive those fees for your applications or petitions. Under the new public charge rule, they are saying if you applied for this fee waiver or your fee waiver was approved, and that is actually a negative factor in your case to find you a public charge. Of course, there are exceptions or exemptions, and I'm going to talk about those exceptions later. But that's the general rule for fee waivers. And also, if even though you have income, they look at your income, even though you have sufficient income, if you used those public benefits that I will tell you later, that would also be a negative factor in your application or petition. And the other factor is the age of the applicant. And it's very interesting because we didn't have this before. So under this new public charge rule, if a person, the applicant, is between the age of 18 and 61-year-old, that's going to be a positive factor for his case. And if the person is younger than 18 or older than 61, that's going to be a negative factor in adjudicating this person's application in order to find if the person is likely to become a public charge or is a public charge. And the other factor is the health of the applicant. So they are looking at the health of the applicant who is filing for the green card either in the United States or overseas through consular processing. So the officer will look if applicant has been diagnosed with one or more health conditions that could require like extensive treatment. And if that's the case, then this is going to be a negative factor in your case. But they are saying if you could show that you have a private health insurance, I will talk about the health insurance later too, but if you can show that you have the ability to pay for these extensive treatment in the United States, then they would consider that as the positive factor, even though being diagnosed of an extensive, a health condition that requires extensive treatment is a negative factor. So, and also they added that it's going to be a heavily positive factor if you can show that you have a private health insurance that is unsubsidized, so you do not receive any subsidy from the government. So that would be heavily positive in weighing the positive and negative factors regarding your health condition. The other factor that they added is actually the family status of the applicant. So they are going to look at your family status. They are going to look at your household size, and they are also looking if you are dependent on any other person's tax returns, which is going to be a negative factor in your case, or if you are actually supporting other people. For example, you have dependents on your tax return, and they are going to look at your household size, and also looking at all the other factors that I told you to see which one is a positive and which one is negative, and they decide under the totality of circumstances if you are a public charge or not. And the other factor that's also interesting is the education and skills. So now, when you are filing your applications or petitions to USCIS or even through consular processing, after February 24, 2020, you need to file new forms along with your adjustment of application or your immigrant visa applications. In those forms you need to answer questions that are related to these factors in the positive and negative factors that I told you. I will explain to you later what these forms are, but in these new forms you have to mention and explain about your education, about your skills, and of course the more educated you are and the more skills you have, then those are actually considered as positive factors in your case, in order for your public charge adjudication. So you gotta mention that, and you also need to submit evidence of those evidence and education and skills requirements. So the officer who is going to actually adjudicate your case will consider whether you have been employed before, or if you are employed currently, and they are going to look at your past 3 years of employment. Like, for example, if you're in the United States and you're filing for your adjustment of status, they're going to look at your past three tax returns for the past 3 years. And if, for example, you have a high school diploma or equivalent, or you have a master's degree, PhD and above, then these are going to be positive factors in your case. And also they're looking at your proficiency in English. So if you are fluent in English, then perfect. So people who are in the United States in applying for their adjustment of status, maybe would not have that issue. But for people who are outside the United States and they want to consular process, then this would be an issue. And they are even requesting in the forms to see if you have any certification to show that you are fluent in English. So being fluent in English is actually highly, or other languages, or other languages would be actually considered heavily positive factor in your case. And they are also looking at the affidavit of support. The affidavit of support has always been there, even before the new public charge rule, for most of like immigration cases, like the adjustment of status cases and applications. People need to submit affidavit of support form along with the required documents to show that either the petitioner, the person who petitioned for someone to file for their green card application, or the co-sponsor, if the petitioner cannot make sufficient income to support the beneficiary of this specific immigration application, would actually be able to support the beneficiary and actually avoid the beneficiary become a public charge in the future after receiving their green cards. So that has always been there, and it has always been a routine. But with this new public charge rule, they are actually looking more deeply to these affidavit of support forms that are being filed, and we see that in practice after February 24, 2020, how they are treating these new affidavit of support that's being filed with either your immigrant visa applications or your adjustment of status applications in the United States. So what happened is, if for example you as the petitioner of the immigrant visa application, for example in a basic marriage-based application, you are the petitioner if you are, for example, a U.S. citizen spouse who is petitioning for your wife to become a lawful permanent resident. So as a petitioner, you have to submit this affidavit of support form, right? Which is I-864 form. And you must show that you have sufficient income under the federal poverty guideline that I told you in the beginning to support your wife. If you cannot make that required income to be the sponsor of your wife, and you must file the affidavit of support even though you do not actually make sufficient income. But if your income is not sufficient, you would need a co-sponsor, like someone else that you add as a joint sponsor or co-sponsor to sponsor your wife financially. So with this new public charge rule, you need to be really careful who the co-sponsor is. So if the co-sponsor is just a random person that you do not know, that's not good for your case. But if the person is, for example, a family member or even a friend, it's better that you be prepared for either your immigrant visa interview or your your green card interview in the United States by providing sufficient evidence that you really know this person who is going to be the co-sponsor, and also this person is really making sufficient income by showing like the W-2s, the tax returns, employer letters, etc., etc. So that's one thing you need to keep in mind, and be careful about your affidavit of support that you're filing after February 24, 2020 with your applications. So now I'm going to the benefits that are actually considered. If you use these benefits, they are considered, you will be considered as public charge. The benefits are actually any federal, state, or local cash assistance for income maintenance, including a TANF, which is temporary assistance for needy families, SSI, and general assistance programs that actually were considered under the previous rule as well. So any cash assistance, if it's either federal or state or local, if you use that within during 12 months in the aggregate within any 36 months, would be considered in adjudication of your case for public charge rules. So be careful about that. And the second public benefit is actually use of Medicaid. And there are actually exceptions of the Medicaid, which are for if you use the Medicaid for emergency services, or you used it as a child under 21-year-old, or as a pregnant woman, which would also include as exception, it would be as an exception for a pregnant woman, even within 60 days after the delivery and their labor. And the other one is a supplemental nutrition assistance program, which is also formerly been called food stamps. So if you use that also, that would be considered for public charge determination. And also federal public housing, Section 8 housing vouchers, and Section 8 project-based rental assistance. So these are the benefits that if you use, you would be considered public charge if the government or adjudicating officers find that you are a public charge because of using these benefits. And use of cash assistance programs or long-term institutional care before February 24, 2020 will still be considered in public charge determination. So this is very important. So even though the new public charge rule is into effect since February 24, 2020, but if you used these cash assistance programs or a long-term institutional care even before February 24, 2020, you would still be considered for public charge determination. And the benefits that are not included are any benefits that's not listed in the new public charge rule, and also DHS will not consider benefits that are received by another person, not the applicant. That's also important. For example, if your child is a U.S. citizen and your child used these benefits, it wouldn't bar you because you are the applicant and your child was a U.S. citizen and actually qualified for those benefits. And also, DHS will not consider non-cash assistance programs. For example, the Medicaid that I told you that are entirely funded by state. and they are entirely local benefits and not federally funded. So if, for example, the Medicaid is entirely funded by the state or local, then that's not considered as public charge. But if it's even partially funded by under federal laws, then it would be considered in public charge determination. That's also you should note. And so the question that people ask a lot are about the disaster relief and the checks that they received, and also unemployment benefits, if they are considered as public charge. So it's specifically stated in the DHS rule that disaster relief or unemployment applications or benefits will not be considered in public charge determination. And also any other, as I told you before, any other benefits that are not listed specifically in either the new public charge rule or the old public charge rules would not be considered as in public charge determination. And so now I'm going to the exceptions, like who actually will be exempted from the of the new public charge rule. So there are some immigrant groups that are not going to be subject to the new public charge rule, including refugees, asylees, and VAWA petitioners, VAWA self petitioners, people who apply for U visa or T visa, special immigrant juveniles, certain humanitarian immigrants, and survivors of trafficking and domestic violence. So these are the groups that are actually exempted from the new public charge rule. And I already told you this, when is the time that a person is going to be considered for public charge. For people who are filing their adjustment of application, a status application in the United States, the adjudicating officer in USCIS is the person who is going to actually determine whether a person who applied for adjustment of status will be a public charge or not. For people who are applying overseas, it's going to be the officer at the consular processing or at the consulate who is actually adjudicating your case. And for your immigrant visa application, you are applying for your immigrant visa and you're applying for admission to the United States. For green card holders, the new public charge rule, people who are already lawful permanent resident, the new public charge rule does not apply to them. But if they have been actually outside the United States for 180 days and more, and they are coming to the US after 180 days, then they might be subject to the new public charge rule by the border officer who is actually asking the questions to see if he or she would be admitted to the United States or not, because you know that people with green card should not be outside the United States for over 6 months or over 180 days. So if they do, they are subject to admission when they are coming back, and the officer at the borders might actually ask them questions about why they have been outside the country for over 6 months. And at that time, if they used the public benefits before, they might be subject to the new public charge rule if the officer determined that. And so be careful about that for people who are green card holders. But if you are going to renew your green card application, then the new public charge rule does not apply to you, because you are only renewing, you are a lawful permanent resident, you are only renewing your green card. So in the renewal of your green card, this new public charge rule would also not apply to you. And also, if you are applying for your citizenship application or naturalization application, the new public charge rule also would not apply to you. So these are actually the notes I wanted to make for lawful permanent residents. How does the new public charge rule apply to non-immigrants? So for non-immigrants, if they are going to, it generally does not apply to non-immigrants, but if they are going to actually extend their status or apply for a change of their status, the new public charge rule might apply to them. And how it applies is also different. The only way it applies to them is if they actually used one or more of the benefits that I told you during the 12 month and the aggregate within any 36 months. So that's actually how it's going to be applied to non-immigrants. And I think I actually covered most of, one more thing about the new public charge rule is for people who are actually seeking coronavirus testings or preventing treatment. Are they going to be counted in immigrants' public charge determination? So on March 13, actually USCIS announced that they will not consider this as a public charge because they want people to seek treatment and to do tests for COVID-19. So if you have been diagnosed with COVID-19 or you have been tested or done any preventive treatment for that, that's not going to affect your immigrant visa application under public charge rule. So now I want to quickly show you the forms for the new public charge rule. So if you are actually doing consular processing, so the new form which is actually issued after February 24, 2020 is called DS 5540, and it's actually in this form. And the form is actually asking about your incomes, and all those factors that I told you are in these forms that you have to give the either for this case the embassy about your education, your skills, your age, if you have health insurance, if you are going to have health insurance within 30 days after arrival to the United States, and etc. And the form that you need to fill out for and submit with your adjustment of application in the United States is going to be I-944, which is this one. This is a very long form, so many pages. And this is in fact more detailed than the consular processing form. And they are basically asking about all those factors that I told you. And now I move to this was actually about the public charge rule. If you have any questions about public charge rule, please write it here so I can answer at the end. Now I'm moving to the effects of COVID-19 on immigration. So what are changed? And I know that we are in a new world with this COVID-19, and everything has been changed. Our routines are changed, our lifestyle is changed. So we're having this presentation live. So yeah, a lot of changes. But with this new COVID-19, not only the United States, but other countries actually took these measures as well to protect their countries from the spread of COVID-19. So what happened in the United States was that President Trump actually issued executive orders regarding the new this COVID-19 issue. And they first issued that this is a national emergency, and then on February 29, 2020, first actually on January 31st, 2020, President Trump issued an executive order banning entry of the people who have been actually traveled to China within the 14 days prior to their arrival to the United States. And then on February 29, 2020, President Trump added more countries to this list that were banned to enter the US if they have been in these countries 14 days prior to their arrivals to the United States. And these countries are China, Iran, European Schengen from European Schengen area, United Kingdom, and Republic of Ireland. So these countries are actually, if you have been in these countries prior to your arrival to the United States for the last 14 days, then you would be banned to enter the US, and this is still into effect. But there are exceptions that actually applies to this executive order, and for sure US citizens are one of the exceptions, and lawful permanent residents or green card holders are another exception to this rule, so they can enter. But if they have been in these countries during the past 14 days, there are precautions taken at the airports or borders. And also another exception is if the alien is actually the spouse of a US citizen or lawful permanent resident. So if you have, for example, your valid immigrant visa and you are the spouse of a lawful permanent resident, and you want to enter the United States with your valid immigrant visa, then you should be able to enter, because spouses of lawful permanent residents or US citizens are exempted from this executive order. Or any alien who is the parent or legal guardian of a U.S. citizen or lawful permanent resident, provided that the U.S. citizen or lawful permanent resident is unmarried and under the year of 21. And then also any alien who is the sibling of a U.S. citizen or lawful permanent resident, provided that both are unmarried and under the age of 21. And there are more exceptions, but you can definitely look at those exceptions through the White House website. These executive orders are all there, and you can see all those exceptions. But these are actually the main exceptions that people mostly ask questions about. Like, I am a spouse of a lawful permanent resident, and I have a valid immigrant visa. What should I do? So you are exempted from this executive order, even though you have been in these countries during the past 14 days. Then after this one, we actually faced another executive order issued by the White House. The new executive order, which is also into effect now, is the proclamation suspending entry of immigrants who present risk to the U.S. labor market during the economic recovery following the COVID-19 outbreak, which was issued on April 22nd, 2020, and it was into effect on April 23rd, and it is valid for 60 days. So this new suspension of entry of immigrants would be only valid for 60 days starting April 23rd. 3rd. So there are also exceptions to this new executive order. So the exceptions are, again, U.S. citizens and lawful permanent residents. And also, this wouldn't apply to people who are filing for their immigrant applications or petitions in the United States. So it only applies to people who are outside the United States. And it also will apply only to people who do not have any valid immigrant visa on the effective date of this executive order, which was April 23rd, 2020. And it applies for people who do not have any other kind of official travel document on the effective date and after within the 60 days. For example, they do not have an advance parole in hand to enter or any other type of travel document issued by the U.S. And the exceptions to this rule are people, so for sure people who does have a valid immigrant visa are actually exempted from this executive order even during the 60 days, and they can enter the United States unless they are subject to the other executive order that I already told you about, like the 14 days that you should keep in mind. And if you are not within one of those exceptions, I know it's very confusing, it's very complicated, but you can definitely have access to these executive orders on the White House website, and you can compare these two executive orders and see if you are subject to one of these orders. And another exception to this new executive order is any alien who is the spouse of a United States citizen. So only if you're a spouse of a U.S. citizen, not a spouse of a green card holder. And also, if you are applying for EB-5 or investor immigrant visas, that is also one of the exceptions. But for my Iranian friends, if you are watching this and you're Iranian, you know about the travel ban, right? So even though the EB-5 is one of the exceptions, we still have the travel ban. And if you cannot show that you qualify for a waiver, then your application would not get approved, even though you are one of the exceptions of this executive order. I know, so many bans and so many confusion. We are doing our best to understand all that. And the other exception is any alien seeking to enter the United States on immigrant visa as a physician, nurse, or other healthcare professional to perform a medical research or other research intended to combat the spread of COVID-19, or to perform work essential to combating, recovering from, or otherwise alleviating the effects of the COVID-19 outbreak. This is also another exception. And there are more exceptions, but these were actually the main exceptions that I wanted to tell you about. And the last thing I wanted to tell you that was actually affected immigration is the in-person interviews or appointments that people have had with USCIS, and they were supposed to go to those interviews. So I know, although you should know that all those interviews have been canceled because USCIS office and also asylum offices and also the other USCIS offices have been closed, and also the court being closed. So the USCIS announced that they will reopen June 4th. So if your appointment, oath ceremony, asylum interview, or any other interview has been canceled, you would receive new notices by USCIS whenever they reopen, which they haven't yet changed it yet. So it's still June 4th that they said they're going to reopen. So check your mailbox to see if you receive the new notices, either to go and do your fingerprints or your new oath ceremony appointments, and don't miss those days. And another question that we receive a lot is what will happen to people, which Yasaman also asked, that if you have been outside of the US because of COVID-19, like for example, you are a green card holder and you have been outside the United States due to COVID-19 and you couldn't have access to a flight to come back to the US, what would happen? The problem is, you know that if you are a green card holder, you must come back to the US within the 6 months of your trip. So you cannot be outside the country over 6 months. But what they said is they are actually going to be flexible about it, and if you can explain to the officer at the airport or the border that you actually missed this 6 month period because there was no flight, and you document all this information that there was no flight to come back to the US, and you could use that as a valid excuse because of the emergency situation that you had. For people who are in the United States, for example, they are on B1, B2 visas, or they actually they needed to leave the country because their visa is not going to be valid anymore. For example, within the next month, 2 months, they did not actually extend your stay, but what they did, USCIS announced on their website that what you can do, you need to file for your either change of your status or extension of your status timely, and even if you file it lately due to COVID-19 situation, USCIS will be flexible about this and would actually consider that when they are adjudicating your case. So that's actually basically all I wanted to discuss. And if you have any questions, I would be more than happy to answer the questions. I already answered Yosaman's question. I'm checking. I don't see any other question. Okay, so thank you very much for being with us and watching my presentation. I hope this whole presentation was helpful for you all, and if you have any specific questions about your case, you can definitely contact my office. And my office is in Los Angeles, and our phone number is 424-402-7053. I also thank you very much, IABA San Diego chapter, for having this opportunity for me to be the guest of IABA. It was a pleasure for me, and I wish you all stay safe and take care of yourself and have a wonderful evening.